Hi, everyone. Thanks so much for having us, and thanks, Kristen, so much for the important words and the introduction. I'm really thrilled to be here today to have this fireside chat with Paul. More than anything, it's just a glimpse for all of you to see the types of discussions Paul and I have day to day. We probably could sit here for 3 hours, but we have a little less time than that. And although he needs no real introduction, I will give it to him because he really deserves it. So as the intro said, Paul is the Chief Legal Officer at Coinbase. He oversees legal, compliance, global intelligence, risk management, and government relations. Before joining Coinbase, Paul was Vice President and Deputy General Counsel at Facebook. And prior to Facebook, Paul was a United States Magistrate Judge for the Northern District of California, and prior to that, a law firm partner. I think Paul's experience as a judge is really important and incisive as we go into today's questions, because as Kristen alluded to, the courts have become more important than ever. A year ago, the crypto regulatory landscape looked very different, to put it mildly, than it does today. And over the last 12 months, we've really been through an extraordinary roller coaster. So first, Paul, a bit of a cheeky question. Do you feel like we are on the upswing or the downswing on this roller coaster in the legal and policy world for crypto?
First of all, it's great to be up here with you. It's wonderful to be with you all this afternoon. Cheeky, perhaps, but I actually think the question is a bit of a trick question because I enjoy going down the roller coasters much more than I do going up. And yet, I think, objectively speaking, we are on the upswing. It may not feel that way right now in crypto, but there's a lot to suggest that our best days lie ahead.
I love that answer, and that goes into sort of what we've really seen over the last 12 months is some really significant positives, I'd say. One is landmark decisions from federal courts, which we'll get into in a second, and then two, we have a proposed comprehensive bill for crypto, the Fit for the 21st Century Act, that's ready to go to the House floor if there's not a government shutdown, and some other serious proposed bills. So I want to unpack that a little bit, and as I said, hearing Paul's perspective on litigation and how it should inform how we're thinking about the space, including how we think about legislation, is really important. So I'm going to start with something that we haven't talked a lot about publicly, but is really important, is the Uniswap litigation. And we will get to what everyone wants to talk about, which is Coinbase's own case too, or a few cases as well. But there is, so just to be a little unpredictable, there was this case, Risley versus Uniswap. It was in front of Judge Failla in the Southern District of New York. And in that case, the court fully dismissed the plaintiff's claims against Uniswap Labs and the Uniswap Foundation and some VCs as well that were brought on for purported violations of the securities laws. What are the most important takeaways for us from the Uniswap case?
So several things I think stand out in my mind. One, this was not a case brought by the SEC. This was a private class action, and yet the federal securities laws were as implicated as if the SEC were a party to the case. The other thing that jumps out in my mind, Rebecca, about the Uniswap decision is that before you even get to the holdings, the rulings that the judge made in really drawing a hard line against holding fraudsters and scammers liable on the one hand, and the intermediate protocols and the people behind those protocols liable on the other, or I should say not liable. She was very clear about that. The decision lays out something that I hope will give all of you even more confidence that as imperfect as judges and courts can be, more often than not, much more often than not, they do the hard work and they do ultimately get things right. And the reason I say all that with reference to this particular case is the background, the facts section, the discussion leading up to the actual legal conclusions of the court are an extraordinarily lucid, extraordinarily thoughtful recitation of how DeFi works, what different actors contribute to the ecosystem, and fundamentally why it makes no sense whatsoever to hold investors and developers of protocols and platforms responsible for what others may do with that when there are perfectly legitimate, indeed very important, legitimate, useful purposes that far outweigh any malevolent activity.
I think that's really important to take away, and I agree that I would say the facts section on how DeFi works is like 95% right, which for a court...
95% is pretty good.
Yeah, I agree. I was just going to say is really amazing because she goes into deep technical detail on how Uniswap works and, as you said, all the different players in the space. Does a case like Uniswap being decided at the motion to dismiss level, if you want to talk about what that means, and being decided in the Southern District of New York, have bearing on what other courts around the country will do? Like, what should we all take away from, this one case?
Well, it's definitely not binding on any other court, but it certainly has, I think, significant bearing on how other courts are going to look at similar issues. And the reason for this is that, as you mentioned, Rebecca, the Uniswap case was a case decided at the very outset of the dispute. When a party accused in a case brings a motion to dismiss, what they're effectively saying to the judge is, as a matter of law, without even getting to who said what or who did what facts will ultimately have to be resolved by a jury in most cases, we can look at the issues in this case and assess them purely on the basis of what the plaintiffs have themselves said happened and apply the law as it currently exists. And there's only one reasonable outcome, only one reasonable conclusion, which is that the defendants in this case are not liable as a matter of law. Now, as I mentioned earlier, this case brought against Uniswap was actually brought against the investors and the developers behind the Uniswap protocol. And what Judge Fela, the Southern District of New York judge, ultimately held was that there was no legal basis to hold the investors and developers responsible because ultimately the developers and investors were not engaged in any of the fraudulent activity, any of the scam behavior, any of the rug pulls that these plaintiffs undeniably suffered from. So in other words, she acknowledged that there was malevolent activity taking place. She acknowledged, and indeed I think expressed some sympathy for real harm being inflicted on real people, and yet the court ultimately concluded that it could not, as a matter of law, hold these particular defendants responsible, no matter how sympathetic the facts might have otherwise been.
Yeah, I thought it was really amazing that she said, like, they don't have anyone who they can hold responsible, so they're looking for somebody, but the law doesn't support this theory.
Exactly.
Yeah. Just to give a little tease, I do think there's some really interesting, important things that came out of the Uniswap decision for Coinbase's case, but we'll hold everybody in suspense on that and turn quickly to two other decisions. One in the Grayscale decision from the Federal Circuit Court in DC. What did the Circuit Court find, and what does it really talk about where the SEC is and how it's perceived and how it's going to proceed to date?
So this, of course, is the case involving Grayscale's application to convert its Bitcoin trust into an ETF. A remarkable decision. Again, even if you don't read a lot of court cases the way that Rebecca and I do on a daily basis, I would encourage you to read this court case. And the reason I encourage you to focus on this particular opinion is that three judges from very different backgrounds, applying three very different judicial philosophies, all concluded one thing, and one thing above everything else, that the SEC not only got it wrong in denying this particular application, but acted arbitrarily, it acted capriciously, it offered an unreasoned explanation for its decision. In judge terms, this is the equivalent of a punch across the jaw. This is how judges make it very clear, and this is the language that courts use to make it very clear that an agency has gone rogue. And I think that for a lot of us in this room and elsewhere who pay very careful attention to these issues, and of course who are directly impacted by how the SEC thinks about these issues, it was just a remarkable and frankly refreshing, Rebecca, moment to see that our government can get it right. It may not often happen outside of the courts these days, but we're just seeing more and more neutral third-party observers looking at the SEC's action and concluding that they're not even acting in a principled basis, regardless of whether or not you agree with them. That's a very important outcome. Now, does it mean that Grayscale's application gets approved immediately? Well, we all know the answer to that is no. The SEC now has the application back. It's got to act on that application shortly. There's a lot of speculation, of course, about what they will do. I don't know what the SEC will do because some time ago I got out of that business of trying to predict what this particular agency will do, regardless of what the law says. But I do know that the message from the 3-judge panel of the D.C. Circuit Court of Appeals could not have been clearer. The SEC needs to rethink its approach when it comes to reviewing not just these types of applications, but the entire regulation by enforcement campaign that's been embarked upon now for some time.
This makes it feel like we're on the upswing on the roller coaster. So I'm going to keep asking these types of questions.
Yeah, let's keep going.
But to your point on, this decision maybe giving some impact to the SEC rethinking its approach, going back to the Uniswap decision for a second, does a private plaintiff case, and I know we're not really predicting SEC behavior, but would a private plaintiff case like that sort of force the SEC to rethink, especially given the type of language that Judge Failla used to say, like, the law doesn't support this, sort of rethink its position on DeFi?
It very much should force the SEC to rethink its position. Again, I've long ago lost confidence that this particular commission necessarily looks to court decisions and takes seriously its responsibility to apply the law as the courts have interpreted it. But even this commission, I think, has to confront the reality that this language was quite stark in the opinion. Courts and judges by nature, by temperament, don't like to go beyond the 4 corners of the dispute before them. It's very rare that you see language included in a written decision that is intended to, for lack of a better way to put it, Rebecca, send a message. I think this decision very much was intended, or certainly reflects an intent to send a message that we need to think of DeFi protocols in the way in which they actually operate in the real world. We can't simply look at them, and by we, I'm referring specifically to regulators, as an end around or as a circumvention of the law. No, they are technologies, period, end stop. And it's not enough to say, well, these outcomes that result from applying the current law to these facts are unsatisfying. If you're not satisfied with the outcome in our system, in the American system, the answer is to change the law. It's not to try to bend and twist the law to make it such that the outcomes are those that you would want to see.
Yeah, and just to sort of bring all these court case questions back to the title of our panel, the Shaping the U.S. Regulatory Environment for Crypto Assets, do you think the courts are really having a big impact on how things are going to move forward, right? We're a little different. We have these 3 branches of government, and the courts are so active here. Even on policy, we have something called impact litigation. You would think of it in something like Brown v. Board of Education, which is like one case that sort of changes how we think about the way the world works. How are you thinking about the courts shaping the U.S. regulatory environment for crypto?
Well, I again, as someone who used to wear a robe and sit in the chambers myself some time ago, I appreciate and respect that most judges, most of the time, don't want to involve themselves in regulatory policy, don't view their role as deciding what is or is not an investment contract or security or any of the other policy questions that we're also concerned about. But when cases are brought, and for the most part, these cases are being brought by the SEC and other regulators, judges have no choice but to act. And I think one thing that gives me a lot of hope is that in each of these cases that we're talking about, including other cases that did not go the defendant's way, I'm referring specifically to the Terraform case, judges are saying in plain and simple terms, we're looking at these technologies, we're applying the law as we are obligated by oath to do, and for example, no, securities law does not apply to tokens in and of themselves. Tokens are not, put another way, securities. Transactions involving tokens, now that might implicate the federal securities laws, but let's not bend and twist terms of art that have been developed and interpreted over decades simply because of a policy preference that may exist today at the SEC. So I actually take a lot of hope from that the courts are willing to apply the law. And at the same time, I do think we all need to be quite skeptical that these decisions are best addressed in court cases, right? Because the fact of the matter is litigation is necessarily backwards looking, right? litigation is expensive. Litigation takes years in most cases to finally resolve. It's just a very poor substitute for thoughtful, sensible rulemaking or legislation that the SEC, other agencies, and Congress could engage in today if there were a will.
You're front running some of my questions, but I'll let it go. But
It's the only time when I will admit to front running anything.
There's lots of talk like, oh, we're all gonna leave the U.S. if there's not regulatory clarity. But our court system is something different and special. It's not used in the same way in Europe and the U.K. in terms of challenging.
Absolutely.
Yeah. So do you think that means something special, or should give consideration to founders who are figuring out where they should set up their business?
Yeah. Look, Coinbase operates globally. Depending on the quarter, 15-20% of our top line revenue now comes from jurisdictions other than the United States. We have a lot of confidence and enthusiasm for other jurisdictions all over the world and the ways in which they're going to contribute to crypto. I want to be very clear about that. And yet, to your point, Rebecca, the American courts remain the gold standard. And that's just not a former American judge saying that because I'm proud of the work that I did and my colleagues continue to do. Talk to judges outside the United States. Talk to lawyers outside the United States. Talk to anyone who has had to try to enforce a contract or other commercial arrangement outside the United States. While there are a number of very fine legal systems operating all over the world, the United States really is, I think, at the top of the list, in large part because we have capable people in these roles, and the public, even today, still has confidence that it may be the one part of our federal government that's still functioning in some real way.
Yeah, just to put a little fine point on that, for the OGs in the room who remember that all of the old contracts used to be under Estonian law, when I was in private practice, which is now like 4 or 5 years ago, I had to bring a case with Estonian counsel over a token issue, and that case still has not been resolved. So I think that puts some fine. So to keep on with the courts a little bit, just to bring back into Terra, how do you think about the Ripple decision and where we are, I guess, procedurally there, and how that also compares to what happened in Terra?
So the Ripple decision, and this is, of course, the decision in which Judge Torres in New York held that secondary transactions did not implicate the federal securities laws in a way that primary transactions could, and as she held in that case, did. It's a watershed moment, and I'm sure many of you in the room, even if not all of you, had the same moment personally that I had and that many of us at Coinbase had when that decision first issued, which was finally, some part of our government was doing the hard work, taking apart these technologies, applying the law, and recognizing that what we have all been saying for now years in trying to bring attention to the SEC's actions was correct, that the SEC was misrepresenting the state of the law and misapplying it in ways that were important and even dangerous. So I think just as a cathartic moment for a lot of us, it was a watershed moment. Now, that decision on secondary trading was one that was disagreed with a short time later in the Terraform decision. Same court, different judge, but critically, a very different posture. And by posture, what I mean is, whereas Judge Torres in the XRP case was looking at these issues at the end of the case, after all of the discovery had been taken, millions of documents produced, hours and hours of witness testimony secured, Judge Rakoff in the Terraform case was looking at it at the beginning of the case, at the stage, as I mentioned earlier, where a motion to dismiss was brought, and the question was, as a matter of law, without looking at any of the facts, could he decide this case one way or the other? There's some unhelpful language, I think it's fair to say, in the Judge Rakoff's decision. I think he gets it wrong, to be blunt, when he speaks to the legal analysis that Judge Torres engaged in when deciding XRP. But again, as I mentioned a few moments ago, even Judge Rakoff in Terraform rejected the fundamental theory that the SEC has been peddling and arguing for years, which is somehow, some way, that tokens, without anything else, were securities under the United States securities laws. That is not the law. That is something now that we've had multiple federal courts reject. And despite all of its disclaimers now that 2 courts have said that's wrong, that is exactly what the SEC has been saying for years. And you don't have to take my word for it or Rebecca's word for it. Go read the complaint in the Ripple case. That's literally what's in black and white. So I think each of these cases offers, again, some encouragement, some cause for hope that the courts are going to hold the SEC accountable and hold them to their pleadings.
Yeah, I do feel, like you said, like a moment, both with Ripple, but really with the Uniswap decision, where I was like, see, we're not being crazy. Like, and
right.
It was a very vindicating moment. I think also one point on Terra is the type of digital assets or crypto assets at issue there were very different. They were marketed differently, and the facts that are alleged in the complaint are not great on the beginning of the case, right? It's the same posture that happened in Uniswap, and it was just a very different posture. So I think there's part of it too. And the last thing I'll say before we get to your case, and that all of these are in the Southern District of New York, which, and I'm interested, the Northern District of California where you sat was also very important, but that is the situs of almost all financial services regulation, important financial services cases and litigation in the country. And so I feel like the fact that these positive decisions are coming out of there is particularly momentous. Do you agree with that idea?
I do, and just to add to your point, Rebecca, which I entirely agree with. Look, for a lot of us in this room who don't live federal securities laws each and every day, or maybe haven't practiced in this area for a terribly long time, it may be surprising, even jarring, to understand that it wasn't that long ago, dare I say, just before this particular administration at the SEC, where the SEC in a court like the Southern District of New York would enjoy massive deference in terms of its understanding an argument of the federal securities laws, and frankly, just massive respect in terms of close calls going to the agency, because judges are generalists. They handle criminal cases one day, civil rights cases the next, and so when they turn to a federal securities law case, they may feel a little bit less experienced and therefore more inclined to take the SEC's word and trust that when they say something is a security, it's actually a security. Each of these cases suggests that deference, that respect is eroding, and it's eroding quickly. And I don't take any particular joy in that, because as someone who's practiced law now for 25 plus years, I want to have federal agencies that are entitled to respect. I want to have experts and subject matter expertise recognized when presented in court. It serves all of our interests for that to be the case. But I'm also gratified that courts, again, are asking hard questions, because as generalists, as non-experts coming to these cases, when they're opening up the file literally for the first time and reading through the materials inside, they're all wondering, this can't possibly be right. They're all questioning whether the SEC is arguing from a place of legal authority or from some type of other agenda that gives them all serious pause.
Yeah, and 2 points to that. It is actually noteworthy that all the judges in these cases are democratically appointed judges. So
it's not a political issue.
Exactly.
Yeah.
Like, this isn't like, that crypto is a partisan issue and it even goes to the courts. It does not. I think the other point I was going to ask you is, do you feel like the policy noise or all the policy dialogue that we're engaged in, that the Blockchain Association is engaged in, that Greg participates in, do you think that's actually been helpful in the courts or the clerks taking a step back and thinking, I really need to think about this case more deeply?
I think it's critical. Look, Coinbase, speaking for myself, we understand we have a unique role in this industry, given that we are the only major publicly listed firm. We've been around for over a decade. We get all that. And so we have taken on the responsibility of arguing these issues and presenting the industry's experience and views, not just for our own interest, although that's obviously something we're here to defend, but for all of our interests. And yet, no one company, no one organization is going to make this case ultimately to the full court. And I'm not just talking about the federal courts, I'm talking about the court of public opinion. And this is where I think, Rebecca, your contributions, Greg's, the blockchain associations, all of you have made a huge difference in shaping how the full court staff, including the judges, but not limited to the judges, understand what is a DeFi protocol. What do we mean when we talk about projects? Who are these characters behind these technologies? Why is this not just a small group of people looking to make a quick buck? Why is it actually the case that we've got now millions of Americans, in fact, 50 plus million Americans who have bought or sold or otherwise engaged with digital assets in some way? Filling out that context, putting a human face and a human voice on these issues is critical. And if I can just say one more thing on this, it's even more critical that a government that purports to act in the interests of each and every one of you, and you, Rebecca, and me, understand what its represented people actually want. Because if elected officials understand that maybe not every American, but a whole lot of them want to see sensible rules adopted, want to follow the law, want to have registrations and frameworks and standards, but want those registrations and frameworks and standards adopted in a sensible way, they will respond. They will respond. That's where I think the advocacy that you've been a part of and many others in this room has been so effective.
I have so many questions. I wish we had all the time for this, but let's turn to, I think what everybody really is interested in hearing about is a bit of the Coinbase case. We know it was brought a day after the SEC brought a case against Binance, and everyone is wondering, or lots of people have asked me, like, why is the Coinbase case moving so much more quickly? And for everybody here, why is that so important?
Well, it was not only brought just a day after Binance, but as you know, Rebecca, it was brought the morning I was actually set to testify before the House Ag Committee on one of the two bills that's now moving to the House floor. And none of that, in my view, was an accident. Now, we didn't choose, perhaps obviously, to be sued by our own federal regulator in federal district court. That's not a place I look forward to being. It carries obvious risk, not just for Coinbase, but for the industry. But having been confronted with this fight, we are now engaging with that fight as aggressively as we can. You know this because you've been lawyering about as long as I have. The conventional wisdom, right, whenever you're sued in district court, certainly by an important federal regulator like the SEC, is to do what? Delay, delay, delay. Can I have an extension, Judge? Can we have more time to produce documents, Judge? Can we put off resolving these issues for another 6 or 12 or 18 months, Judge? That is the playbook that young lawyers and not so young lawyers are taught over and over again whenever confronted with a monumental challenge like the one that we have been presented with. We have chosen, as you suggest, Rebecca, to take a very different course. And there are a lot of reasons for that, but I think they all boil down to one thing, which is we can't wait. We can't wait. This industry is moving too fast. Our international competitors outside the United States are certainly not waiting around for the U.S. to get its act together. And so there's an old saw that you know well that I think applies in our case as much as any other that I'm aware of, which is that justice delayed is justice denied. A win 5 years from now or 10 years from now means very little when this industry is moving quickly, this market is moving quickly, and this technology needs to evolve quickly in order to address all of the very real problems with the traditional financial and non-financial systems that we're all interested in. So for all of those reasons, we have tried in every way we know how to get the key issues in the case resolved by the court sooner rather than later. And to my great delight, and frankly, I could not appreciate the court's candor and care on this more, the court agreed to take up a number of key legal issues early, and that's why we brought a motion for judgment on the pleadings, which is a formal way of saying to the court, decide our case as a matter of law, just a few short weeks ago.
Yes, so this means Coinbase didn't produce documents, didn't do the hours of witness testimony. You're sort of in the same posture that the Uniswap decision was in, but slightly different, but it still would get rid of the whole case if Judge Failla agrees with you on your motion.
Absolutely. And to be very clear,
and can you tell everybody sort of what the motion you made says and what it would really do?
Happy to talk about the motion. I will just say as a predicate to that, discovery, as you know, cuts both ways. And while we will certainly meet every obligation we have under the federal rules of civil procedure to produce documents and witness testimony,
Sure.
like I have every intention, as I believe is our right under the law, to take discovery of the SEC on these same issues, because it's time that they account for their positions. And they explain why they have dropped this load on our entire industry without any basis in law. Now, you were asking about our motion. At the root of our motion for judgment on the pleadings is a simple argument, really, that whatever else you may think about this market and this industry, the SEC doesn't have the jurisdiction that it claims. The SEC claims, of course, that it has jurisdiction over nearly every token or every project. It has grudgingly given up Bitcoin.
Yeah.
Grudgingly. It has purposefully kept the industry in the dark about ETH. And as to every other token, their position is, we'll tell you when we tell you, which is their way of saying we can take it all and exercise authority over it all. That's plainly not the law. That's plainly not reconcilable with decades of precedent from the Supreme Court and other important courts in our country. And so we will be arguing to this court that as they have pled their claims, the SEC lacks jurisdiction over the projects, other products, other services that are at issue in our complaint. Now, I happen to think we've made a compelling argument in our opening papers, but the court will ultimately have the final say on that.
Yeah, and just as Paul told you to read the Grayscale decision, even if you're a non-lawyer, you must read Coinbase's motion. As somebody who's practiced as a litigator, financial services and otherwise, it is one of the most beautifully written pieces of legal mastery that I have ever read. So you guys should do it. It was really great.
I appreciate that. I will say beauty and legal writing is not normally something that you hear side by side, but I am quite proud of the work that our team did.
I mean, there's things like the SEC can't shove these words in, the court's mouths and in Howie's mouth and stuff. It was great.
And I also want to recognize and acknowledge, Rebecca, because it's important. We filed our brief, and as I said, I happen to think it's persuasive. I'm hopeful the court will agree, but time will tell on that. A number of other parties filed what are called amicus briefs in support of our position. And I think actually in many ways, the association briefs, the briefs from the law professors that were filed, a whole host of them, all make the case as eloquently or more eloquently than we ever could. And I'm grateful for that support. And a number of those folks are represented here in this room, so I want to say thank you personally for that.
Yeah. And to your point about Judge Rakoff, one of the amicus briefs actually says right at the end, Judge Rakoff, you're wrong, in the same court that he's in.
Not an easy thing to do because, federal judges don't often get told in such stark terms that they're wrong. And look, we have a lot of respect for that particular judge. We have a lot of respect for all of the courts in which we find ourselves. But judges do get it wrong, and it's important that we be clear, even if respectful, where they get it wrong, and if nothing else, to make sure that same mistake isn't repeated in subsequent cases.
So three last questions, and I'll let you sort of just wrap it all
Sure.
up. But one, in the Uniswap case that we started with, Judge Failla made a statement that issuers of tokens, and she goes, these are software developers, do not register tokens with regulatory agencies, and she says because neither Congress nor the courts have weighed in on whether those are securities, commodities, or something else entirely. And I know we're not reading tea leaves here, but sort of what do you think the impact is on the Coinbase case? And then the last two things I'll say, just to be able to close it out, is, we've talked all about the courts. What, does this mean, we should be emboldened and we don't want legislation anymore because we have this huge piece of really important legislation pending? And the last piece is, what would you want everyone to walk out of here thinking they should be doing next to make sure that we continue to push the regulatory environment for crypto forward in the U.S.?
All fantastic questions. Let me try to answer them succinctly. As for the recognition in the Uniswap decision that registration is an illusion, or the opportunity to meaningful register is an illusion for most token projects, what can I say except yes. Yes, and I think that does have significant implications, not just for our case, but for many other cases that have been brought by the SEC. The fact of the matter is, and the folks in this room or others watching this can speak to this far more eloquently than I can, it is simply impossible to register with the SEC, period, end stop. And so for the court to recognize that, I thought was important. You next asked about legislation. As hopeful as I am that this court and other courts will continue to hold the SEC accountable, it's critical that we get legislation passed by this Congress without any further delay. There are two bills pending right now in the House. One, a market structure bill, and the other, a bill on stable coins. They obviously address different elements of our market, but they are both important. Neither is perfect. I want to acknowledge that and recognize that at the outset. There are serious issues that still need to be addressed, still need to be frankly corrected, that I think will be addressed and corrected as the bills move forward. But this is our best shot to get sensible standards enacted by Congress so that on a going forward basis, the SEC, the CFTC, and others are operating according to law. That's all that any of us involved in these issues have ever wanted, and these offer the best opportunity for that to happen. Your final question, Rebecca, was what can any of us do to continue to make progress on the issues? There's an important grassroots movement that I think is taking shape quite nicely called Stand with Crypto. Coinbase happens to support Stand with Crypto, but it's a separate organization with a separate mandate. And its mandate is pretty simple. How can we engage the 52 million Americans who have already adopted crypto in their financial and non-financial lives in some way and make sure that their voices get heard as Congress debates whether or not to pass these bills and move forward with the legislation that we've been talking about? It's critical that all of us get involved with Stand with Crypto. It's critical that whether you use that organization's resources or otherwise, you let your elected officials know that you care about this issue, that you'd like to see them pass sensible legislation, and that we're all going to hold our lawmakers accountable if they continue to screw around with this issue and push innovation, jobs, and frankly, American leadership overseas. So standwithcrypto.org is a great way to get involved. It literally breaks it down in very simple steps, how to call, how to email, how to register your opinion. But however you do it, however you get involved, it's critical that we all get involved in some way. We can't look forward to waste any more time, and the time to act is now.
I couldn't think of a better way to end this. Paul, thank you to you and to Coinbase and to your policy team there who do so much work in this space, and thank you for being here and having this chat.
Thank you, Rebecca. Thank you all.